You're just a janitor. What could you possibly know about constitutional law? Harold Crane's voice echoed through the marble corridors of Whitmore Associates, his words dripping with the kind of arrogance that only came from 3 decades of never being wrong. He stood towering over Daniel Davis, who clutched a worn legal brief in his calloused hands at 11:47 p.m., the fluorescent lights casting harsh shadows across the empty law firm. But what this prestigious senior partner didn't know was that the man in the gray custodial uniform standing before him had just identified the constitutional loophole that could save an innocent woman from life imprisonment, a solution that had eluded his entire team of Harvard and Yale-educated attorneys for 8 grueling months. What happened next would expose the fatal flaws in a legal system that values pedigree over principle and transform how this elite Manhattan law firm views justice itself. Before we jump back in, tell us where you're tuning in from, and if this story touches you, make sure you're subscribed, because tomorrow I've saved something extra special for you. The case seemed impossible from the beginning. Victoria Hartwell, a 34-year-old single mother and community organizer from the Bronx, sat in Rikers Island facing a life sentence for a murder she didn't commit. The evidence against her was overwhelming. Security footage placing her near the scene, her fingerprints on the murder weapon, and a motive rooted in her public disputes with the victim, corrupt city councilman Richard Morrison. But Victoria maintained her innocence with a conviction that her court-appointed public defender had long since abandoned. That's when her sister Sarah, working 3 jobs to pay for private representation, had managed to scrape together enough money to hire Whitmore Associates, one of the most prestigious criminal defense firms in New York City. The firm's reputation was built on impossible victories, on finding legal miracles where others saw only defeat. Harold Crane himself had personally taken the case, confident that his legendary courtroom skills could unravel what appeared to be an airtight prosecution. For 8 months, the legal machine had churned. Teams of associates pulled all-nighters researching precedents. Expert witnesses were consulted at astronomical fees. Private investigators retraced every step of the investigation. Computer forensic specialists analyzed digital evidence frame by frame. The firm had spent over $800,000 of the family's life savings, money borrowed against Sarah's house, money that represented generations of working-class sacrifice. Yet despite all their expertise, all their resources, all their prestigious legal education, Harold Crane and his team had found nothing. Every appeal had been denied, every motion dismissed, every legal strategy had crumbled against the weight of evidence that seemed insurmountable. The trial was set to begin in just 4 days, and Victoria Hartwell was going to prison for the rest of her life for a crime she didn't commit. The law firm's conference room had become a graveyard of discarded theories. Whiteboards covered in scratched-out timelines and crossed-out witness lists stood as monuments to their failure. Associates who had started the case with bright-eyed optimism now avoided eye contact during strategy meetings. Harold Crane, a man who had never lost a high-profile case in his career, was facing the prospect of sending an innocent woman to die behind bars. It was in this atmosphere of desperate defeat that Daniel Davis had made his discovery. For 6 years, he had cleaned the offices of Whitmore Associates during the graveyard shift, invisible to the lawyers who worked there. They saw him as furniture, a necessary but forgettable part of the building's infrastructure. What they didn't see was the way his eyes lingered on the legal documents scattered across their desks, the way he absorbed their heated strategy discussions, the way his mind automatically began analyzing the cases that kept these brilliant legal minds awake at night. Tonight, as Daniel emptied the waste paper baskets in Conference Room A, he had seen the Hartwell case files spread across the massive oak table like pieces of an impossible puzzle. The prosecution's evidence was displayed in neat stacks: photographs, witness statements, forensic reports, surveillance footage stills. But as Daniel studied the arrangement, something had clicked in his mind, a connection that 8 months of expert legal analysis had somehow missed. The Fourth Amendment, unreasonable search and seizure, the very foundation of criminal procedure that every first-year law student learned. Yet somehow, in all their complex strategizing, Harold Crane's team had overlooked the most fundamental constitutional protection of all. The search warrant that had led to Victoria's fingerprints being found on the murder weapon, it was flawed. Not just procedurally flawed, but constitutionally invalid, in a way that would make every piece of evidence derived from it inadmissible in court. Victoria Hartwell could walk free. But Harold Crane didn't see a brilliant legal mind when he looked at Daniel Davis. He saw a janitor with a mop and a superiority complex, a working-class nobody who had somehow convinced himself he understood the sophisticated practice of law. The confrontation in the hallway was about to become the moment that would change everything, not just for Victoria Hartwell, but for everyone who had ever been dismissed because of their uniform rather than their intellect. This story will make you question everything you thought you knew about intelligence, about justice, and about who truly has the power to save lives when the system fails. Because sometimes the most profound legal insights come not from corner offices, but from someone humble enough to see what arrogance had blinded others to miss. Preparing and narrating this story took us a lot of time, so if you are enjoying it, subscribe to our channel. It means a lot to us. Now, back to the story. What Harold Crane failed to understand in that moment was that Daniel Davis wasn't just any janitor. He was a man whose legal mind had been forged in the very halls of Harvard Law School, only to be buried beneath years of financial desperation and family obligation. The constitutional violation Daniel had discovered wasn't lucky guesswork. It was the product of a brilliant legal intellect that had been invisible to everyone around him for 6 long years. When Daniel walked into that law firm's corridor at midnight with his discovery, he wasn't just challenging Harold Crane's ego. He was about to shatter the entire foundation of how Whitmore and Associates determined who was worthy of respect. Because in the next 4 days, this dismissed custodial worker would accomplish what $800,000 in legal fees and 8 months of elite legal strategy had failed to achieve. He would save Victoria Hartwell's life and expose a justice system that had nearly condemned an innocent woman because of institutional blindness. The shock waves from this confrontation would ripple far beyond the marble halls of one Manhattan law firm. Harold Crane's world of privilege and presumption was about to collide with a truth that would force him to question everything he believed about intelligence, worth, and who deserves a voice in the pursuit of justice. This story will challenge every assumption you've ever made about expertise, credentials, and the hidden brilliance that walks among us in plain sight. Because sometimes the most profound legal victories come not from those with corner offices and Ivy League diplomas prominently displayed on their walls, but from someone humble enough to see the constitutional truth that arrogance had rendered invisible. By the time this case reaches its conclusion, Victoria Hartwell will walk free. Harold Crane will never look at competence the same way again, and an entire legal system will be forced to confront the devastating cost of judging minds by their uniforms rather than their insights. Dear viewer, if you are watching my story for the first time, I humbly request you write the location from where you are watching right now. Subscribe to this channel and press the bell icon to not miss the notifications of my daily published new stories. Thank you, and let's dive into this extraordinary true story that will forever change how you see the people around you. Before we continue, I want you to think about someone in your life who has been overlooked, dismissed, or underestimated because of their job title, their appearance, or their background. Perhaps it's the security guard who always has thoughtful insights, the restaurant server who speaks multiple languages, or the maintenance worker who seems to understand complex problems better than the managers. Keep that person in mind as we explore Daniel Davis's journey, because this story isn't just about one man's fight for recognition. It's about the countless brilliant minds that our society renders invisible every single day. The legal system, perhaps more than any other institution, prides itself on precedent, on hierarchy, on the careful cultivation of expertise through years of formal education and prestigious credentials. Law schools like Harvard, Yale, and Columbia don't just educate future attorneys. They create an exclusive fraternity where worth is measured by class rank, law review membership, and the prestige of your first clerkship. This system produces lawyers like Harold Crane, men and women who believe that true legal insight can only emerge from those who have walked the approved path, who have earned their place through the traditional gatekeepers of legal knowledge. But what happens when that system fails? What happens when all the credentials, all the prestigious degrees, all the expensive legal strategies prove inadequate against the weight of seemingly insurmountable evidence? What happens when an innocent woman sits in a jail cell, counting down the days until a life sentence, while the very people society trusts with justice struggle helplessly against their own limitations? This is where our story becomes more than just a tale of one man's hidden talents. This is where it becomes a mirror held up to every institution that confuses credentials with capability, that mistakes pedigree for performance, that allows prejudice to blind them to the very solutions they desperately need. Because Daniel Davis's discovery of the constitutional violation that could save Victoria Hartwell wasn't an accident. It was the inevitable result of a mind trained to see what others miss, a perspective shaped by years of observing the legal system from the outside. You see, Daniel's position as the night janitor at Whitmore Associates had given him something that even the most brilliant attorneys in the firm lacked: objectivity. While Harold Crane and his team were buried deep in the complexities of the case, overwhelmed by the forest of legal precedents and procedural strategies, Daniel could see the trees. His outsider status, the very thing that Harold dismissed him so completely, was precisely what allowed him to spot the fundamental constitutional flaw that had been hiding in plain sight. The irony is breathtaking when you really consider it. Here was a law firm that billed clients $1,200 per hour for legal expertise, whose partners charged premium rates specifically because of their elite educational backgrounds and decades of courtroom experience. They had assembled a dream team of legal minds: Harold Crane, with his legendary reputation for impossible victories; associate partner Jennifer Walsh, with her expertise in constitutional criminal defense; Senior Associate Michael Torres, with his background in federal appeals; and Research Director Amanda Foster, with her encyclopedic knowledge of Supreme Court precedent. Together, this legal powerhouse had consumed 8 months and nearly $1 million in pursuit of a strategy that could save Victoria Hartwell. They had explored every angle, challenging the reliability of eyewitness testimony, questioning the chain of custody for physical evidence, investigating potential police misconduct, analyzing the victim's background for alternative suspects, even considering an insanity defense despite Victoria's obvious mental competence. They had hired private investigators who traced Victoria's movements for weeks before the murder, computer experts who enhanced surveillance footage frame by frame, and forensic specialists who re-examined every piece of physical evidence with state-of-the-art technology. Yet for all their efforts, for all their expertise, for all their prestigious credentials and expensive resources, they had missed the most fundamental protection in criminal law: the Fourth Amendment to the Constitution, the cornerstone of criminal procedure that every law student learns in their first semester, had been violated so blatantly that the case should have been dismissed months ago. But it took the fresh eyes of a janitor, someone completely outside their insular world of legal strategy and courtroom politics, to see what they had all been blind to. This oversight wasn't just professional embarrassment. It was a devastating indictment of how elite institutions can become so consumed with their own sophistication that they lose sight of basic principles. It revealed how the very expertise they prided themselves on could become a limitation, how their deep immersion in complex legal theory had caused them to overlook the simple constitutional foundation that should have been their starting point. The tragedy extends beyond just this one case, beyond just Victoria Hartwell's 8 months of wrongful imprisonment. How many other clients had suffered because of this institutional blindness? How many other innocent defendants had been failed by a system that valued complexity over clarity, prestige over principle? And how many other Daniel Davises were out there right now, invisible to the very institutions that could benefit from their insights, dismissed because they wore the wrong uniform or lacked the right credentials? As we prepare to dive deeper into Daniel's extraordinary background and the events that led him to that midnight moment of discovery, remember that this story is ultimately about all of us. It's about the assumptions we make, the people we overlook, and the hidden potential that surrounds us every day. It's about the courage to challenge systems that fail, and the humility to recognize that wisdom doesn't always come from where we expect it. So let's continue this journey together and discover how one man's quiet determination to seek justice would transform not just Victoria Hartwell's fate, but the very foundation of how we understand expertise, intelligence, and who truly deserves to be heard when justice hangs in the balance. The fluorescent lights hummed softly as Daniel Davis pushed his cart through the 32nd floor of the Meridian Tower, home to Whitmore Associates, at exactly 10:30 p.m. For 6 years, this had been his sanctuary, the quiet hours when the building's 847 employees had gone home, leaving behind only the security guards, the occasional workaholic attorney, and Daniel himself. The night shift suited him perfectly. It paid 30% more than day cleaning, the work was peaceful, and most importantly, it allowed him to be home when his 12-year-old daughter Emma woke up for school. Daniel's routine was precise, almost ritualistic in its efficiency. He would start with the executive suites on the 40th floor, work his way down through the partners' offices, then tackle the associate bullpen, the conference rooms, and finally the support staff areas. Each office told a story through its organized chaos. The criminal defense attorneys with their evidence boards and witness photos, the corporate lawyers with their stacks of merger documents, the family law practitioners with their boxes of tissues strategically placed for emotional clients. But it was in the criminal defense wing where Daniel lingered longest, not because the cleaning took more time, but because the work itself fascinated him in ways he couldn't fully explain to his colleagues. While emptying wastebaskets, he would catch glimpses of legal briefs, witness statements, and court filings. During his break times, he would sometimes sit in the empty conference rooms, surrounded by the detritus of legal strategy sessions, and find himself mentally organizing the information, spotting patterns, questioning assumptions. His co-workers at Morrison Building Services, the contracted cleaning company that employed him, knew Daniel as the quiet guy who always volunteered for the law firm contract. Maria Santos, who cleaned the insurance offices on floors 20 through 25, would often joke that Daniel had a thing for lawyers. "Maybe you're hoping one of those rich attorneys will notice you and offer you a job," she would tease during their shared lunch breaks in the basement employee area. Daniel would just smile and change the subject. How could he explain that he wasn't attracted to the wealth or prestige of the legal profession, but to the intellectual challenge of it? How could he tell Maria that every time he saw a complex legal problem spread across a conference table, his mind automatically began working through the issues, identifying weaknesses in arguments, spotting procedural gaps, constructing alternative strategy?
The truth was, Daniel Davis had a secret that would have shocked not just his cleaning crew colleagues, but every attorney at Whitmore Associates who walked past him as if he were invisible furniture. 15 years ago, he had been a different person entirely. Daniel Davis, first-year student at Harvard Law School, ranked 14th in his class of 534, with a partial scholarship and a burning ambition to become a criminal defense attorney who would fight for the voiceless and the overlooked. Those had been the best 8 months of his life. The intellectual rigor of constitutional law, the elegant complexity of legal reasoning, the profound responsibility of a justice system that could elevate or destroy human lives, it all felt like coming home to a language he had been born to speak. His professors had noticed his analytical abilities, particularly Professor Elizabeth Kane, who taught criminal procedure and who had begun mentoring Daniel toward a potential Supreme Court clerkship after graduation. But life, as it often does, had other plans. The call came on a Tuesday evening in February during his second semester. His younger sister, Rebecca, who had been raising her infant daughter alone after her boyfriend abandoned them, had been diagnosed with acute lymphoblastic leukemia. The medical bills were catastrophic, the prognosis uncertain, and Rebecca was only 22 years old with no insurance and no savings. Daniel had faced an impossible choice: continue his legal education while his sister potentially died from lack of proper medical care, or leave Harvard to work full-time and support Rebecca's treatment. For someone who had grown up in a family where loyalty meant everything, where his grandmother had sacrificed her own dreams to raise him and Rebecca after their parents died in a car accident, there was really no choice at all. He had withdrawn from Harvard Law School on a Friday afternoon in March, telling Professor Kane that it was a temporary leave of absence, that he would return the following year once the family crisis was resolved. Professor Kane had written a letter of recommendation that would hold his place. The admissions office had granted him a deferred enrollment, and Daniel had believed with all his heart that this was just a detour, not a destination. But Rebecca's treatment stretched on for 2 years. Even with Daniel working double shifts at a manufacturing plant, the medical debt continued to mount. When Rebecca finally achieved remission, she was weak, exhausted, and unemployed, with a 3-year-old daughter who barely knew her mother outside of hospital rooms. Daniel had become the family's anchor, the financial provider, the stable presence that kept their small household together. The years passed in a blur of work and responsibility. Rebecca eventually regained her health and found steady employment as a medical technician, a career choice inspired by her own medical journey. Her daughter, Daniel's niece Lily, grew from a confused toddler into a bright, curious child who called Daniel Uncle Danny and considered him more father than uncle. When Daniel met Sarah Williams, a kind-hearted elementary school teacher with a young daughter of her own, and they fell in love and married, his family responsibilities only deepened. Emma, Sarah's daughter, embraced Daniel as her stepdaughter with the wholehearted acceptance that only children can offer. Sarah understood Daniel's financial obligations to Rebecca and never pressured him to abandon his sister's family, even when it meant they lived in a modest apartment instead of buying a house, even when it meant Daniel worked nights and weekends to make ends meet. By the time the family's financial situation had stabilized enough that Daniel could theoretically consider returning to law school, 15 years had passed. His Harvard deferment had long since expired. At 38 years old, with a wife, a stepdaughter, and ongoing financial obligations, the idea of taking on massive student loan debt for 3 more years of law school seemed impossibly impractical. So Daniel had made peace with his situation, or at least he thought he had. He found work with Morrison Building Services, specifically requesting assignment to legal offices because something about the environment felt like home. During Emma's homework time, he would help her with her studies, often drawing on analytical thinking skills that impressed her teachers. When Sarah's school had budget cuts that eliminated their legal aid program, Daniel had quietly helped several families navigate immigration paperwork and tenant rights issues, though he was always careful to clarify that he wasn't a licensed attorney. The night shift at Whitmore Associates became his compromise with destiny, close enough to the legal world to feed his intellectual hunger, invisible enough to avoid awkward questions about his background. He told himself that this was enough, that vicarious engagement with legal challenges through his cleaning work could satisfy the part of him that still dreamed of courtrooms and constitutional arguments. But deep down, Daniel knew he was lying to himself. Every time he witnessed legal strategies that he could improve, every time he spotted procedural errors that experienced attorneys had missed, every time he saw clients like Victoria Hartwell facing injustice while their expensive legal teams struggled with problems that seemed solvable to him, the old hunger stirred. The part of him that had thrived in Harvard's intellectual crucible, that had been shaped by Professor Kane's mentorship, that understood law not just as a profession but a calling, that part of him had never really accepted exile. Tonight, standing in conference room A at 11:30 p.m., staring at the evidence that would either convict or exonerate Victoria Hartwell, Daniel Davis was about to discover that some compromises with destiny are only temporary, and that brilliance, once awakened, never truly sleeps.
But then he thought about justice itself, about the constitutional principles he had once sworn to uphold, about the fundamental promise that every American citizen deserved protection from government overreach. Victoria Hartwell was innocent. Daniel was certain of that now, not just because of her consistent protestations, but because the evidence against her had been gathered illegally. She was sitting in a jail cell not because she was guilty, but because the system had failed to recognize its own constitutional violations. The moment of decision crystallized as Daniel carefully photographed the incident report with his personal cell phone, making sure to capture the previously hidden text in sharp detail. He wasn't just documenting evidence, he was crossing a line from observer to participant, from invisible custodian to active advocate for justice. He knew that approaching Harold Crane directly would be futile. The partner's reaction to any suggestion from a janitor would be immediate dismissal. But Daniel also knew that in 4 days, when Victoria Hartwell was convicted and sentenced to life imprisonment, he would have to live with the knowledge that he could have prevented that injustice. He would have to explain to Emma why sometimes good people don't speak up when they have the power to help. He would have to look at Sarah, who had dedicated her career to fighting for vulnerable children, and know that he had abandoned a vulnerable woman when she needed him most. As Daniel finished cleaning conference room A and moved his cart toward the hallway, he carried with him more than just the photographic evidence of Detective Rodriguez's constitutional violation. He carried the weight of choice, the burden of knowledge, and the dawning realization that his exile from the legal profession was about to end. Not through any formal rehabilitation or credential restoration, but through the simple moral necessity of speaking truth to power when justice hung in the balance. The clock on the conference room wall read 12:15 a.m. In less than 12 hours, Harold Crane would arrive at the office to begin his final preparations for a trial he believed was hopeless. What Harold didn't know was that the solution to his seemingly impossible case was walking down the hallway at that very moment, pushing a cleaning cart and wearing a gray custodial uniform, about to transform from invisible observer to the most important voice in Victoria Hartwell's fight for freedom. Daniel had intended to wait until morning, to find some subtle way to bring his discovery to the attention of Harold Crane's legal team. Perhaps he could leave the clean document positioned strategically where someone would notice the previously hidden text. Maybe he could mention it casually to one of the younger associates who might be more open to unexpected insights. But as he pushed his cart past Harold Crane's corner office at 12:45 a.m., he saw the lights still blazing and heard the unmistakable sound of frustration. Papers being shuffled aggressively, a coffee mug hitting the desk with more force than necessary, and the low muttering of a man at war with an impossible situation. Through the half-open door, Daniel could see Harold pacing behind his massive mahogany desk, his usually pristine appearance disheveled after hours of futile strategizing. His Harvard law diploma hung prominently on the wall behind him, flanked by photographs of Harold shaking hands with senators, federal judges, and other legal luminaries. The office was a monument to legal achievement. Leather-bound case reporters lined the walls, prestigious awards gleamed from glass cases, and oil paintings of Supreme Court justices gazed down with stern authority. Harold was on the phone with someone, his voice carrying the sharp edge of professional desperation. "Margaret, I don't care what time it is in Seattle. I need you to review every piece of forensic evidence one more time. There has to be something we missed, some procedural flaw, some expert witness inconsistency, anything that could create reasonable doubt." The phone call ended with Harold slamming the receiver down harder than necessary. Daniel heard him mutter something about impossible cases and legal miracles. That's when Daniel made his decision. He knocked gently on the office doorframe. Harold looked up, his face cycling through confusion, annoyance, and barely contained frustration.
"The cleaning can wait until tomorrow," he said dismissively, not even bothering to make eye contact. "Mr. Crane," Daniel said quietly, stepping into the office despite not being invited, "I think I might have found something that could help with the Hartwell case." The transformation in Harold's expression was immediate and dramatic. Confusion melted into disbelief, then hardened into the kind of cold anger that Daniel had seen directed at opposing counsel during depositions. Harold slowly rose from his chair, his 6-foot frame imposing even in his exhausted state. "I'm sorry, what did you just say?" Harold's voice was dangerously quiet. Daniel reached into his pocket and pulled out his phone, displaying the photograph of the incident report. Detective Rodriguez's own documentation shows that he conducted the search without reasonable articulable suspicion. The Fourth Amendment violation is clear, and under the exclusionary rule—
"Stop!" Harold's voice cut through the air like a blade. "Stop right there!" He walked around his desk, moving closer to Daniel with the predatory grace of a man accustomed to intimidating opponents. "Are you seriously telling me that you, a janitor, think you found a constitutional violation that my entire legal team missed?" "The coffee stain was covering the crucial text," Daniel continued, his voice steady despite his racing heart. "I only noticed it tonight when I was cleaning the conference table. If you examine the document under proper lighting—" "You're out of your mind." Harold's laugh was sharp and humorless. "Do you have any idea who I am? Do you understand what you're suggesting?" Daniel met Harold's gaze directly. "I'm suggesting that Victoria Hartwell is innocent and that the evidence against her was obtained illegally. The Supreme Court's decision in Silverthorne Lumber clearly establishes that." "Enough!" Harold's voice exploded through the office. "You're quoting Supreme Court cases at me? You think because you've overheard some legal terminology while emptying waste baskets that you understand constitutional law?" "I understand it because I studied it at Harvard Law School," Daniel said quietly. The words hung in the air between them like a challenge. Harold's face went through another series of expressions: disbelief, suspicion, and something approaching rage. "Harvard Law School," Harold repeated slowly. "You're telling me that a janitor claims to have attended Harvard Law School? My Harvard Law School? I was there for 8 months before I had to leave for family reasons. Professor Elizabeth Kane taught my criminal procedure course. Judge Patricia Vance, who signed the warrant in Victoria's case, was a guest lecturer in our constitutional criminal defense seminar." Harold's face had gone pale. Daniel could see the mental calculations happening behind his eyes. The specific names, the detailed knowledge, the impossible claim that was starting to sound less impossible with each piece of corroborating information. "Even if that were true," Harold said, his voice dropping to a dangerous whisper, "even if you somehow managed to attend Harvard for a few months 15 years ago, you're still just a janitor. You're still someone who empties my trash and mops my floors. You don't get to waltz into my office at midnight and lecture me about constitutional law." Daniel felt a familiar anger rising in his chest. Not the hot rage of personal offense, but the cold fury of injustice recognized. "Victoria Hartwell is going to prison for life on Monday morning because you're too proud to listen to someone in a custodial uniform. How is that different from the prejudice that put her in jail in the first place?" "How dare you?" Harold hissed. "I have spent 8 months and nearly $1 million of this firm's resources trying to save that woman. I have explored every possible legal avenue, consulted with dozens of experts, and pursued every lead no matter how remote. Don't you dare suggest that I haven't done everything possible for my client. You've done everything except look at your own evidence. Detective Rodriguez's incident report has been sitting in your conference room for 8 months. The constitutional violation is documented in the prosecution's own paperwork.
But you never saw it because it was hidden under a coffee stain. And more importantly, because you would never imagine that someone like me could spot what someone like you missed." Harold's hands clenched into fists at his sides. "Get out! Get out of my office right now before I call security and have you fired." "Fire me if you want," Daniel said, his voice gaining strength. "But first, look at the evidence. Look at Detective Rodriguez's own admission that he had no reasonable suspicion. Look at the timeline that shows the search preceded any legal justification. Look at the constitutional violation that invalidates everything the prosecution claims to have found." "I said get out," Harold's voice echoed through the office. Daniel pulled out his phone again, setting it on Harold's desk with the photograph clearly visible. "Victoria Hartwell's freedom is worth more than your ego, Mr. Crane. When you're ready to admit that justice matters more than pride, the evidence will be waiting for you." He turned and walked toward the door, his heart pounding but his steps steady. Behind him, he heard Harold's voice, shaking with rage and something that might have been uncertainty. "You're delusional if you think I'm going to base a legal strategy on the fantasies of a janitor who claims he went to law school." Daniel paused at the doorway and looked back. "I'm not asking you to trust me, Mr. Crane. I'm asking you to trust the Constitution. The evidence speaks for itself, if you're willing to listen." As Daniel walked down the hallway, he could hear Harold's office door slam shut with enough force to rattle the walls. But he had seen something in the attorney's eyes during those final moments. A flicker of doubt, a hint of possibility, the beginning recognition that maybe, just maybe, the impossible had actually happened. Daniel arrived home at 7:30 a.m. to find Emma already at the kitchen table, her math homework spread out alongside a half-eaten bowl of cereal. She looked up as he entered, her 12-year-old face creased with worry that seemed far too mature for her age. "Dad, there's a problem?" she said without preamble. "Mrs. Henderson wants to meet with you and Mom about my disruptive behavior in social studies class." I hung his jacket on the back of a chair and sat down across from his stepdaughter, noting the air quotes she made around disruptive behavior. "What kind of disruption are we talking about?" Emma's cheeks flushed red. "She was teaching about the Constitution yesterday, and she said that the police can search anyone's house if they have probable cause. But that's not right, Dad. They need a warrant unless there are special emergency circumstances." I raised my hand and tried to explain about the Fourth Amendment protections, but she told me I was being argumentative and disrupting the lesson. The irony hit Daniel like a physical blow. Here was his daughter facing the same institutional resistance to constitutional knowledge that he had encountered with Harold Crane just hours earlier. The parallel was so stark it took his breath away. "What exactly did you tell Mrs. Henderson?" Daniel asked gently. "I said that the Supreme Court has ruled that police need either a warrant signed by a judge or exigent circumstances, like someone destroying evidence or immediate danger. I mentioned the case we talked about last month, the one where the police couldn't search the house just because they smelled marijuana." Daniel remembered that conversation. Emma had asked him about a news story she'd seen, and he had carefully explained the constitutional principles involved, the same way he helped her with algebra or science homework. He had never considered that his legal knowledge might create problems for her at school. "Mrs. Henderson said I was showing off and making other students feel stupid," Emma continued, her voice small. "She said that 12-year-olds don't need to know about complicated legal stuff and that I should stick to what's in the textbook." Sarah emerged from the bedroom, already dressed for her teaching job at Riverside Elementary. She kissed Daniel's forehead and ruffled Emma's hair before pouring herself coffee. "Rough night?" she asked Daniel, noting the tension in his shoulders. "Something like that," Daniel replied. "Emma was just telling me about her social studies situation." Sarah's expression darkened. "Mrs. Henderson called yesterday evening. She wants a conference about Emma's know-it-all attitude and suggested that maybe we're pushing her too hard academically at home." Sarah's voice carried the controlled anger of a teacher who understood exactly what was happening. Basically, she's punishing Emma for being smart and well-informed. Daniel looked at his daughter, seeing in her frustrated expression the same sense of injustice he had felt standing in Harold Crane's office. Emma was being dismissed, not because she was wrong, but because her knowledge didn't fit Mrs. Henderson's expectations of what a 12-year-old should know. The institutional prejudice was identical, just scaled down to a middle school classroom. "It's not fair, Dad," Emma said quietly. "I wasn't trying to show off. I just wanted her to teach the right information. What if some kid in our class grows up thinking the police can search their house whenever they want? What if they don't know their rights?" The question pierced Daniel's heart. This was exactly why he had fallen in love with constitutional law 15 years ago, the profound responsibility of protecting individual rights against government overreach. Emma understood that responsibility instinctively, but her teacher saw it as disruption. Sarah sat down at the table, studying Daniel's face carefully. "There's something else going on, isn't there? You look like you've been wrestling with something all night." Daniel hesitated, then told them about his discovery in the Hartwell case, about his confrontation with Harold Crane, about the constitutional violation that could free an innocent woman. He explained how his legal knowledge, the same knowledge that was getting Emma in trouble at school, might be the key to preventing a devastating miscarriage of justice. Sarah said when he finished, "You found evidence that could save this woman's life, but the lawyer won't listen to you because you're a janitor." "That's about the size of it," Daniel admitted. Emma's eyes were wide. "But Dad, if you know she's innocent, you have to help her. You can't just let her go to prison." "It's not that simple, sweetheart. Mr. Crane doesn't believe that someone like me could understand constitutional law well enough to—" "Someone like you?" Emma interrupted. "You mean someone who actually knows what they're talking about? Someone who studied this stuff at Harvard?" Daniel smiled sadly. "Someone who empties trash cans for a living. Someone who doesn't have the right credentials or the right title." Sarah reached across the table and took his hand. "Daniel, you've helped more people with legal problems in the past 6 years than most lawyers help in their entire careers. Remember when Mrs. Rodriguez was facing eviction because her landlord was violating housing codes? Remember when the Nguyen family needed help with their immigration paperwork? Remember when Emma's friend Tyler's father was being harassed by debt collectors who were breaking federal law?" Daniel did remember. In each case, he had quietly researched the relevant laws, helped families understand their rights, and guided them toward proper legal resources. He had always been careful to clarify that he wasn't a licensed attorney, but his knowledge had made real differences in real people's lives. "This is different," Daniel replied. "This is a murder case. This is someone's entire life hanging in the balance." "Exactly," Emma said with the fierce certainty that only children possess. "That's why it matters more, not less. Dad, you always taught me that standing up for what's right is more important than being comfortable. You always said that knowledge comes with responsibility." Sarah nodded. "She's right, Daniel. And there's something else to consider. What message does it send to Emma if you walk away from this? What does it teach her about using her knowledge to help others?" Daniel looked at his daughter, seeing the same passion for justice that had driven him to law school all those years ago. Emma was facing her own version of Mrs. Henderson's institutional prejudice, her own battle against a system that preferred conformity to correctness. If he gave up on Victoria Hartwell because Harold Crane couldn't see past his uniform, what was he teaching Emma about the value of fighting for truth? His phone buzzed with a text message. It was from Rebecca, his sister. "Saw the news about that murder trial starting Monday. The woman's case sounds hopeless. Thank God nothing like that will ever happen to Lily or Emma. They'll have you looking out for them." The message hit Daniel with devastating clarity. Rebecca was right. His family would never face the kind of systematic injustice that Victoria Hartwell was experiencing because they had him. They had someone who understood their rights, who could navigate legal complexities, who would fight for them when institutions failed. Victoria Hartwell had no one, except Harold Crane's legal team, and they had already given up. Emma was watching him carefully. Dad, what would happen to me if I were ever in trouble and no one would listen to you because of your job? The question hung in the air like a challenge. Daniel realized that this moment wasn't just about Victoria Hartwell or Harold Crane or even his own abandoned legal career. This was about the kind of man he wanted to be, the kind of father he wanted Emma to remember, the kind of example he was setting for a daughter who already understood that knowledge came with the obligation to use it for justice. "You're right," Daniel said, "both of you. This isn't about Harold Crane's prejudices or my wounded pride. This is about Victoria Hartwell's right to competent legal representation. And if her own lawyer won't look at exonerating evidence because of where it came from, then someone else has to make sure that evidence gets heard." Sarah squeezed his hand. "What are you going to do?" Daniel thought about Professor Kane, about the constitutional principles she had taught him, about the oath he had never formally taken but had always carried in his heart. "I'm going to find another way to get this evidence in front of someone who will take it seriously. And I'm going to teach Emma that sometimes fighting for justice means accepting that the system won't make it easy for you." Emma grinned. "And I'm going to tell Mrs. Henderson that I learned about constitutional law from someone who actually knows what he's talking about, job title or no job title." As Daniel prepared for a few hours of sleep before what he knew would be the most important day of his life, he realized that his daughter had just taught him something profound. Credentials didn't create integrity. Institutions didn't define intelligence. And sometimes the most important battles were fought not by people in power, but by people who refused to accept that power was a prerequisite for standing up for what was right. Friday afternoon arrived with the weight of inevitability. Daniel had managed only 3 hours of sleep before his phone rang at 10:30 a.m. with a call that would change everything. The voice on the other end was crisp, professional, and utterly unexpected. "Mr. Davis? This is Jennifer Walsh, associate partner at Whitmore Associates. I understand you had a conversation with Harold Crane last night about the Hartwell case." Daniel sat up in bed, instantly alert. Jennifer Walsh was Harold's second in command on the criminal defense team, a brilliant attorney who had graduated summa cum laude from Columbia Law and had been mentioned in legal journals for her innovative appellate strategies. Why was she calling him? "Yes, ma'am, I did." "I need to see the evidence you mentioned. Can you meet me at Riverside Diner on Amsterdam Avenue in 30 minutes? And, Mr. Davis, come alone." The diner was a classic New York establishment with red vinyl booths and black and white checkered floors. The kind of place where attorneys never held meetings, but where a janitor and a lawyer might have coffee without drawing attention. Daniel arrived first, choosing a corner booth where they could speak privately. Jennifer Walsh entered at exactly 11 a.m., her designer suit slightly out of place among the construction workers and taxi drivers who comprised the diner's usual clientele. She was younger than Daniel had expected, probably in her early 30s, with intelligent brown eyes behind wire-rimmed glasses and an expression that suggested she was taking a considerable risk by being there. "Mr. Davis," she said, sliding into the booth across from him, "show me what you found." Daniel pulled out his phone and displayed the photograph of Detective Rodriguez's incident report. Jennifer studied it intently, her expression growing more serious with each passing second. She pulled out her own phone and began cross-referencing something, her fingers flying across the screen. "My God," she whispered after several minutes, "how did we miss this?" "The coffee stain covered the crucial text for months," Daniel explained. "I only saw it clearly when I cleaned the table Thursday night." Jennifer looked up from her phone, studying Daniel with new intensity. "Harold told me you claim to have attended Harvard Law School. Is that true?" 8 months, 15 years ago. I had to leave when my sister got sick." "Professor Kane?" "Criminal procedure, constitutional criminal defense seminar. Judge Vance was a guest lecturer on warrant requirements." Jennifer nodded slowly. "I called Professor Kane this morning. She remembers you. Said you were one of the most analytically gifted students she'd taught, and that your withdrawal was one of the biggest losses the legal profession had suffered in years." The words hit Daniel like an unexpected gift. After 15 years of exile from the legal world, knowing that Professor Kane remembered him with such regard felt like a validation he hadn't realized he desperately needed. "Mr. Davis," Jennifer continued, "this constitutional violation you've identified, it's not just a minor procedural flaw. This completely destroys the prosecution's case. Everything flows from that illegal search. The murder weapon, the stolen items, even the witness statements that came after neighbors saw the police activity. All of it becomes inadmissible under the exclusionary rule." "I know," Daniel said quietly. "The problem is, I can't present this to the court, not officially." Daniel's heart sank. Because it came from a janitor? Because Harold Crane is the lead attorney on this case, and he's made it clear that he considers your involvement to be unprofessional interference. He's forbidden anyone on the team from pursuing what he calls the janitor's fantasy theory. The injustice of it was staggering. An innocent woman would go to prison because the lead attorney's ego couldn't accept that someone in a custodial uniform had found the solution he'd missed. Jennifer leaned forward, her voice dropping to barely above a whisper. "But there might be another way. Are you familiar with the concept of pro se representation?" Daniel's pulse quickened. "When a defendant represents themselves in court." "Exactly. Victoria Hartwell has the constitutional right to fire her current counsel and represent herself. And if she chooses to do so, she can accept legal advice from anyone she wants, including someone who isn't licensed to practice law, but who has significant legal knowledge." The implications began crystallizing in Daniel's mind. "You're suggesting that Victoria fire Harold Crane and represent herself with my assistance?" "I'm suggesting that Victoria Hartwell deserves to know about the evidence that could exonerate her, regardless of who discovered it. Whether she chooses to act on that information is entirely up to her." Daniel felt the ground shifting beneath him. This wasn't just about providing information anymore. This was about stepping into the arena, about taking responsibility for Victoria's defense in a way that would put him directly in opposition to one of New York's most powerful law firms. "Jennifer, Miss Walsh, if I do this, Harold Crane will make sure I never work in a legal environment again. He'll have me blacklisted from every building in Manhattan that houses a law firm." "Probably," Jennifer agreed. "And if you don't do this, Victoria Hartwell will spend the rest of her life in prison for a crime she didn't commit, while the real killer remains free. The choice is yours, Mr. Davis, but I need you to understand something. This isn't just about one case anymore." She pulled out a tablet and showed him a news article from that morning's New York Times. The headline read, "High-profile murder trial highlights flaws in criminal justice system." The article discussed how Victoria's case had become a symbol of the challenges facing indigent defendants, even those who could afford private representation. "The legal community is watching this case," Jennifer continued. "If Harold's traditional approach fails and Victoria is convicted, it reinforces the narrative that some cases are simply unwinnable. But if new evidence emerges that exposes a fundamental constitutional violation that experienced attorneys missed, it raises uncomfortable questions about how our profession operates." Daniel understood. This had become bigger than Victoria Hartwell's individual case. This was about whether the legal system could adapt when its own prejudices blinded it to justice. "There's something else you should know," Jennifer said. "I've been researching your background since Professor Kane confirmed your story. You're not the only one. There are dozens of brilliant legal minds working in non-legal jobs because life circumstances prevented them from completing law school or passing the bar. Our profession is hemorrhaging talent because we've created a system that values credentials over capability." She leaned back in the booth, studying his face. "This case could change that. Not immediately, not dramatically, but it could start a conversation about how we identify and utilize legal expertise. It could create pathways for people like you to contribute to justice in meaningful ways." Daniel thought about Emma, about her fight with Mrs. Henderson, about the parallel battles against institutional prejudice that seemed to define their family's existence. He thought about Sarah, who had chosen teaching because she believed in nurturing potential wherever she found it. He thought about Rebecca, whose medical crisis had derailed his legal career, but who had emerged stronger and more compassionate. "What exactly are you proposing?" Jennifer pulled out a business card and wrote something on the back. "Meet me at the courthouse tomorrow morning at 8 a.m. I'll arrange for you to speak with Victoria Hartwell privately. You can explain the constitutional violation you discovered and let her make an informed decision about her representation. If she chooses to proceed with Harold's team, nothing changes. If she chooses to represent herself with your assistance, then you'll have the weekend to prepare for the most important trial of your life." Daniel stared at the business card, feeling the weight of decision. "And if I fail, if my legal knowledge isn't enough to save her, then you'll have failed honorably, fighting for justice instead of accepting injustice. But Mr. Davis," Jennifer's voice carried absolute conviction, "you won't fail. Professor Kane was right. You have a gift for legal analysis that doesn't depend on credentials. And Victoria Hartwell deserves to have that gift working for her instead of being wasted on cleaning floors."
As Daniel walked home from the diner, the business card felt like a gauntlet thrown down by destiny itself. In less than 18 hours, he would either retreat to the safety of his custodial routine or step into the legal arena where his knowledge would finally be put to its ultimate test. The choice was his, but deep in his heart, Daniel knew the choice had already been made the moment he decided that Victoria Hartwell's freedom mattered more than his own security. The trial of Victoria Hartwell would begin Monday morning, but Daniel Davis's real trial, his test of courage, conviction, and constitutional knowledge, would begin tomorrow at 8 a.m. in a courthouse where credentials mattered less than truth, and where justice would finally have the advocate it deserved. The meeting with Victoria Hartwell took place in a sterile conference room at the Manhattan Detention Complex, separated by reinforced glass that made every conversation feel like a desperate negotiation with fate itself. Victoria sat across from Daniel wearing an orange jumpsuit that seemed to swallow her small frame, her dark eyes carrying the hollow exhaustion of someone who had spent 8 months preparing to say goodbye to her son forever. Jennifer Walsh had arranged the meeting through careful legal maneuvering, claiming that Victoria had requested to consult with a legal researcher about her case. Technically true, though the full implications of what Daniel was proposing would have sent Harold Crane into a rage that could be heard from Midtown Manhattan to the Bronx. "Mrs. Hartwell," Daniel began, his voice gentle but urgent, "I need to show you something that could change everything about your case." Victoria looked at him with the skeptical wariness of someone who had heard too many promises from too many lawyers. "Are you another attorney? Because I have to tell you, I'm pretty much done with attorneys. They've had 8 months to find something, anything, that could help me, and all they've done is spend my sister's life savings on expert witnesses who can't explain away the evidence." Daniel pulled out his phone and placed it on the small table between them, the photograph of Detective Rodriguez's incident report clearly visible on the screen. "I'm not an attorney, Mrs. Hartwell. I'm someone who believes you're innocent and who found evidence that proves the police violated your constitutional rights." For the next 20 minutes, Daniel walked Victoria through the constitutional violation step by step. He explained how Detective Rodriguez's own admission that he lacked reasonable articulable suspicion made the entire search illegal. He detailed how the exclusionary rule would invalidate every piece of evidence obtained from that search. He showed her the legal precedents that supported their position and outlined exactly how this violation could lead to her immediate freedom. Victoria listened with growing intensity. Her legal mind, she had been a paralegal before becoming a community organizer, quickly grasping the implications of what Daniel was explaining. By the time he finished, tears were streaming down her face. "You're telling me that the evidence to free me has been sitting in Harold Crane's conference room for 8 months?" "Hidden under a coffee stain, but yes.
The prosecution's own documentation proves they violated your Fourth Amendment rights. Victoria was quiet for a long moment, processing not just the legal implications, but the bitter irony of her situation. And Mr. Crane won't use this evidence because it came from a janitor, Daniel finished, someone he considers unqualified to understand constitutional law. Victoria's expression hardened with a familiar anger, the same righteous fury that had driven her community organizing, the same passion for justice that had put her in conflict with corrupt city councilman Richard Morrison in the first place. "What are you proposing, Mr. Davis?" "I'm proposing that you fire Harold Crane and represent yourself, with me as your legal advisor. Under pro se representation, you have the right to consult with anyone you choose, regardless of their formal credentials. Together, we can present this constitutional violation to the court and secure your freedom." The weight of the decision settled over Victoria like a physical presence. Firing Harold Crane meant abandoning the most prestigious criminal defense attorney in New York, a man whose reputation had been built on impossible victories. But that same reputation was now working against her, his pride preventing him from accepting that his janitor had solved the case that stumped his entire legal team. "If we do this," Victoria said slowly, "if I represent myself with your help, what are our chances?" Daniel met her gaze directly. "Legally, the constitutional violation is clear and the precedent is overwhelming. Any honest judge would have to suppress the evidence. But Mrs. Hartwell, I need you to understand what you'd be risking. You'd be betting your freedom on the legal knowledge of someone who never finished law school, someone who hasn't practiced law a day in his life." Victoria was quiet for another moment, then asked a question that cut straight to the heart of everything. "Mr. Davis, do you believe I'm innocent?" "Absolutely." "And do you believe this evidence would prove my innocence?" "Beyond any doubt." Victoria nodded slowly. "Then I'd rather trust someone who believes in my innocence and understands the law than someone who thinks I'm probably guilty but might get me off on a technicality." The decision made, Daniel and Victoria spent the rest of Saturday and all day Sunday in intensive preparation. Jennifer Walsh, operating in deliberate defiance of Harold Crane's explicit orders, provided them with complete access to the case files, legal databases, and conference room facilities at Whitmore Associates. She couldn't officially participate in their strategy sessions, but she made sure they had every resource they needed. Daniel's legal knowledge, dormant for 15 years, awakened with startling clarity. The constitutional principles Professor Kane had taught him felt as familiar as breathing. The case law research skills he had developed during those 8 months at Harvard returned with the fluency of a native language. Most importantly, his outsider's perspective allowed him to see strategic opportunities that traditional legal thinking might have missed. Victoria proved to be an ideal client for pro se representation. Her paralegal background had given her familiarity with court procedures and legal terminology. Her community organizing experience had taught her how to present complex information clearly and persuasively. Most importantly, her genuine innocence gave her a moral authority that no amount of legal theatrics could manufacture. They worked through every aspect of the case methodically. Daniel drafted the motion to suppress evidence based on the Fourth Amendment violation, carefully citing every relevant precedent from Mapp v. Ohio through the most recent Supreme Court decisions on search and seizure law. Victoria practiced presenting the motion, learning to speak with the confidence of someone who understood both the law and the righteousness of her cause. But their preparation went beyond just the constitutional violation. Daniel had noticed other weaknesses in the prosecution's case. Inconsistencies in witness testimony, gaps in the timeline, forensic evidence that raised more questions than it answered. While the Fourth Amendment violation would be sufficient to secure Victoria's freedom, Daniel wanted to ensure they had multiple lines of defense. By Sunday evening, they had constructed what Daniel believed was an airtight legal strategy. The motion to suppress evidence was comprehensively researched and clearly written. Victoria was prepared to present their arguments with both legal precision and emotional authenticity. They had anticipated every possible objection from the prosecution and prepared responses that demonstrated not just legal knowledge, but genuine understanding of constitutional principles. As they reviewed their final preparations, Victoria asked Daniel a question that revealed the deeper significance of what they were attempting. "Mr. Davis, win or lose, what we're doing tomorrow is going to change things, isn't it? Not just for me, but for other people who don't fit the system's expectations of what expertise looks like." Daniel considered her words carefully. "I think you're right. If we succeed, it proves that legal knowledge exists outside traditional institutions. If we fail, at least we'll have demonstrated that fighting for constitutional principles matters more than protecting professional pride." Victoria smiled for the first time since he'd met her. "Either way, my son will see that his mother didn't go down without a fight, and maybe other people in situations like yours will realize that their knowledge and insights matter, even if the system doesn't recognize them." As Daniel prepared to leave the detention center that evening, Victoria offered him a handshake that felt like a covenant. "Thank you for seeing what others couldn't see, Mr. Davis. Not just the constitutional violation, but my innocence. Tomorrow, we're going to prove that justice doesn't require permission from people who think they own it." Walking home through the streets of Manhattan, Daniel felt the weight of what they were about to attempt. In less than 12 hours, he would step into a courtroom where his 15 years of exile from the legal profession would either end in vindication or disaster. But regardless of the outcome, he knew that Victoria Hartwell would face her trial with the best legal defense her case allowed. Not because her attorney had the most prestigious credentials, but because her advocate understood both the law and the moral imperative to fight for the innocent, no matter the personal cost. Monday morning arrived with the weight of destiny pressing down on courtroom 15B in the New York County Criminal Court. Judge Patricia Vance, the same jurist who had unknowingly signed the flawed warrant 8 months earlier, called the court to order at exactly 9 a.m. The gallery was packed with reporters, legal observers, and members of Victoria's community who had organized to support her through what everyone expected to be a hopeless final stand. Harold Crane sat at the defense table in his perfectly tailored suit, surrounded by 3 associates and enough legal briefs to stock a small law library. His expression carried the resignation of a man who had already mentally prepared his statement to the press about how some cases simply couldn't be won, regardless of the attorney's skill or dedication. But Harold's carefully constructed narrative was about to be demolished by the most unexpected development in his 30-year legal career. "Your Honor," Victoria Hartwell stood at the defense table, her voice clear and strong despite the orange jumpsuit that marked her as the accused. "Before we proceed with jury selection, I have a motion to present to the court." Judge Vance looked puzzled. "Ms. Hartwell, your attorney, Mr. Crane, is perfectly capable of presenting motions on your behalf." "Your Honor, as of this morning, I am representing myself pro se. I have dismissed Mr. Crane and his team from my case." The courtroom erupted in whispers and shuffled papers. Harold Crane's face went through a spectrum of emotions: confusion, disbelief, embarrassment, and finally a cold fury that promised consequences for whoever had orchestrated this professional humiliation. Judge Vance banged her gavel. "Miss Hartwell, I strongly advise against representing yourself in a capital murder case. Mr. Crane is one of the most respected criminal defense attorneys in New York. I understand the risks, Your Honor, but I have the constitutional right to represent myself. I have consulted with a legal advisor who has identified crucial evidence that previous counsel chose not to pursue." Harold Crane stood abruptly. "Your Honor, I object to any suggestion that my representation was inadequate. This appears to be a desperate stunt orchestrated by someone seeking to disrupt these proceedings." Victoria turned to face Harold directly. "Mr. Crane spent 8 months and nearly $1 million missing a constitutional violation that was documented in the prosecution's own evidence. If that isn't inadequate representation, what is?" The judge's gavel came down harder this time. "Miss Hartwell, what is the nature of your motion?" Victoria took a deep breath, feeling the weight of her son's future, her community's faith, and Daniel's quiet confidence all resting on her shoulders. Your Honor, I move to suppress all evidence obtained from the search of my apartment on the grounds that Detective Rodriguez violated my Fourth Amendment rights by conducting a warrantless search without reasonable articulable suspicion or exigent circumstances. Assistant District Attorney Michael Torres stood, his expression suggesting he was dealing with an amateur who didn't understand the legal complexities of her situation. Your Honor, this motion was thoroughly examined during pretrial hearings. The search was conducted pursuant to valid probable cause and— Your Honor, Victoria interrupted. May I present Detective Rodriguez's own incident report, filed 30 minutes after the search? She approached the bench and handed Judge Vance a copy of the document Daniel had discovered, with the previously hidden text now clearly highlighted. The judge studied it carefully, her expression growing more serious with each line she read. Detective Rodriguez states here that he initiated the search without reasonable articulable suspicion of immediate danger or evidence destruction. Judge Vance read aloud, "Mr. Torres, how do you reconcile this admission with your claim of valid probable cause?" ADA Torres took the document, his confidence evaporating as he realized what he was looking at. Your Honor, this appears to be a clerical error in the detective's report. The search was clearly justified by what? Victoria's voice carried the authority of someone who had spent years fighting for justice in her community. Your Honor, Detective Rodriguez's own words admit that he lacked the reasonable suspicion required under Terry v. Ohio for any investigative detention, much less the exigent circumstances required under Kentucky v. King for a warrantless entry. Judge Vance looked up sharply. Miss Hartwell, you're citing some fairly sophisticated constitutional law for someone representing herself. Victoria smiled slightly. Your Honor, I've had excellent legal guidance from someone who understands constitutional principles better than many licensed attorneys. From the gallery, Daniel Davis watched with pride and terror as Victoria presented the legal arguments they had crafted together. Every constitutional principle Professor Kane had taught him 15 years ago was flowing through Victoria's presentation with clarity and precision that would have impressed any appellate court in the country. ADA Torres was scrambling now, realizing that his entire case was collapsing in real time. Your Honor, even if there were procedural irregularities in the initial search, the inevitable discovery doctrine would still require you to prove that the evidence would have been discovered through lawful means. But you can't make that showing because Detective Rodriguez admits in his own report that he had no lawful basis for being at my apartment in the first place. Harold Crane watched this constitutional massacre with growing amazement and horror. The janitor, the night custodian he had dismissed so contemptuously, had not only identified a case-ending constitutional violation, but had apparently taught this woman enough law to argue it more effectively than some attorneys he knew. Judge Vance was studying the incident report again, cross-referencing it with other documents in the case file. Mr. Torres, I'm having difficulty understanding how your office proceeded with this prosecution, knowing that Detective Rodriguez had documented his own admission of constitutional violations. Your Honor, that section of the report was unclear due to a stain on the original document. Are you telling me that critical constitutional violations were overlooked because of poor document maintenance? The silence in the courtroom was deafening. ADA Torres had no answer that wouldn't make his office look either incompetent or deliberately indifferent to constitutional rights. Victoria pressed her advantage. Your Honor, under the exclusionary rule established in Mapp v. Ohio and refined in subsequent Supreme Court decisions, evidence obtained through constitutional violations must be suppressed. The murder weapon, the allegedly stolen items, and the witness statements that emerged only after neighbors saw police activity, all of this evidence is fruit of the poisonous tree and must be excluded. Judge Vance set down the documents and looked at both attorneys. Mr. Torres, without the evidence obtained from the apartment search, what remains of your case against Miss Hartwell? The prosecutor's silence answered the question more eloquently than words. Without the illegally obtained evidence, the prosecution had nothing but circumstantial connections that wouldn't survive a motion to dismiss. "Miss Hartwell," Judge Vance said finally, "your motion to suppress evidence is granted. Mr. Torres, I am ordering you to review every piece of evidence in this case and determine what, if anything, remains that was not tainted by the constitutional violation documented in Detective Rodriguez's report." ADA Torres stood slowly, the defeat written across his face. "Your Honor, given the scope of the constitutional violation and the extent to which subsequent evidence derived from the illegal search, the people moved to dismiss all charges against Victoria Hartwell." The courtroom exploded in cheers and applause. Victoria collapsed into her chair, 8 months of terror and desperation finally releasing in a flood of tears. In the gallery, her sister Sarah was sobbing with relief, while community members who had supported her through the ordeal celebrated a victory that had seemed impossible just hours earlier. Harold Crane sat motionless at the defense table, staring at the woman who had just accomplished what his entire legal team couldn't achieve in 8 months of intensive effort. The constitutional violation had been hiding in plain sight, documented in the prosecution's own evidence, waiting for someone with the humility to see past their own prejudices and the legal knowledge to understand its significance.
As the judge formally dismissed all charges and ordered Victoria's immediate release, Daniel Davis slipped out of the gallery and walked quietly toward the courthouse exit. His work was done. Victoria Hartwell was free. Justice had been served, and the legal system had been forced to confront its own blindness to constitutional violations that had been staring it in the face for 8 months. But as Daniel reached the courthouse steps, he heard his name called from behind. Victoria Hartwell, now a free woman, was running toward him with tears streaming down her face and the biggest smile he had ever seen. "Mr. Davis," she called out, her voice carrying across the courthouse plaza. "Thank you for seeing what they couldn't see. Thank you for believing in justice even when the system had given up on it." As reporters and legal observers began to understand who Daniel was and what role he had played in this stunning legal victory, the questions began flying. But Daniel Davis, the janitor who had just outperformed one of New York's most prestigious law firms, simply smiled and walked home to tell his daughter that sometimes fighting for what's right really does make a difference. The aftermath of Victoria Hartwell's vindication spread through New York's legal community like a constitutional earthquake, shaking the foundations of every assumption about expertise, credentials, and who deserved to be heard when justice hung in the balance. By Tuesday morning, the story had transcended local legal circles and captured national attention, with headlines that would have been unthinkable just 48 hours earlier. "Janitor's legal brilliance frees innocent woman after prestigious law firm failed," read the front page of the New York Times. The Washington Post led with "Constitutional violation hidden in plain sight, how working-class legal minds succeeded where elite attorneys failed." Legal blogs, constitutional law professors, and criminal justice reform advocates were dissecting every aspect of the case, trying to understand how such a fundamental violation of Fourth Amendment rights had been overlooked by experienced attorneys for 8 months. Harold Crane arrived at his office Wednesday morning to find 3 resignation letters on his desk and a conference room full of partners demanding explanations. The firm's reputation, built over decades of high-profile victories, had been shattered not by a rival law firm or a brilliant prosecutor, but the very janitor who had cleaned their offices while they strategized their way to professional humiliation. "How the hell did this happen, Harold?" Senior partner Margaret Davidson's voice carried the icy fury of someone whose professional world had just collapsed. "We had 12 attorneys working on this case. We consulted with constitutional law experts from 3 universities. We hired private investigators, forensic specialists, and appellate consultants. How did a janitor spot what we all missed?"
Harold sat heavily in his leather chair, looking older than his 58 years. The evidence was there all along. Detective Rodriguez's incident report documented his own constitutional violation, but it was hidden under a coffee stain. We never cleaned the document thoroughly enough to see the full text. That's not an answer, Harold, said criminal defense partner David Chen. That's an excuse. Even if we missed the stained document, how did we miss the constitutional analysis? This wasn't some obscure legal theory. This was basic Fourth Amendment law that every criminal attorney should recognize. The truth was more painful than Harold wanted to admit, even to himself. They had been so focused on complex legal strategies, so committed to sophisticated approaches that would showcase their expertise, that they had overlooked the fundamental constitutional protections that should have been their starting point. They had been operating like surgeons who forgot to check if the patient was breathing. But the professional reckoning at Whitmore Associates was just one ripple in a much larger wave of institutional self-examination. By Thursday, the New York State Bar Association had announced the formation of a committee to study non-traditional legal expertise and its role in criminal justice. Law schools were scheduling symposiums on hidden legal minds and professional blindness. The story had become a mirror held up to an entire profession, forcing uncomfortable questions about whether legal education and professional gatekeeping were serving justice or merely protecting privilege. Daniel Davis found himself at the center of a media storm he had never sought. Reporters camped outside his apartment building, eager for interviews with the man who had accomplished what elite attorneys couldn't. Legal headhunters called offering positions at prestigious firms. Law schools reached out about teaching opportunities, honorary degrees, and speaking engagements. But the most meaningful recognition came from an unexpected source: Judge Patricia Vance herself. "Mr. Davis," she said when she called him personally on Thursday evening, "I've been a judge for 20 years, and I've never seen a more thorough understanding of constitutional criminal procedure displayed by someone without formal legal credentials. Your analysis of the Fourth Amendment violation was not just correct, it was exemplary." "Thank you, Your Honor, but I was just applying principles that Professor Kane taught me 15 years ago." "Mr. Davis, what you accomplished goes far beyond academic knowledge. You demonstrated the kind of legal insight that comes from genuine understanding of constitutional principles, not just memorization of case law. The legal profession needs minds like yours, regardless of traditional credentialing." Professor Elizabeth Kane herself had reached out to Daniel within hours of the verdict, their conversation bridging 15 years of separation with the warmth of shared intellectual passion. "Daniel," she said, "what you did in that courtroom represented everything I hope to teach about constitutional law, that these principles exist to protect real people facing real injustice, not just to provide intellectual exercises for law students."
She had news that would change everything. Harvard Law School was creating a special pathway program for students who had been forced to leave due to family circumstances. Daniel would be the first candidate admitted under the new program, with full scholarship support and credit for his demonstrated legal expertise. "Professor Kane," Daniel said, his voice thick with emotion, "I'm 38 years old, with a family to support. Starting over seems—" "You're not starting over, Daniel. You're continuing from where you left off, with 15 years of real-world experience that most law students will never have. You've already proven that you understand law at a deeper level than many practicing attorneys. Now we're just going to make it official." But perhaps the most profound transformation was happening within the criminal justice system itself. District Attorney Maria Santos announced a comprehensive review of all cases handled by Detective Rodriguez, looking for other instances where constitutional violations might have been overlooked. The police department implemented new training protocols on search and seizure law, using Daniel's discovery as a case study in how procedural shortcuts could undermine legitimate law enforcement. Victoria Hartwell, meanwhile, had become a powerful advocate for criminal justice reform, speaking at legal conferences about her experience and the systemic failures that had nearly destroyed her life. Her 8-year-old son Marcus, who had spent months preparing to grow up without his mother, now introduced Daniel as the man who brought mommy home whenever they encountered him at community events.
The ripple effects extended beyond New York's legal community. Law firms across the country began examining their own hiring practices, wondering how many brilliant legal minds they had overlooked because those minds were attached to people who cleaned their offices, served their coffee, or worked in their mailrooms. Bar associations started discussing alternative pathways to legal practice for people with demonstrated expertise but non-traditional backgrounds. Harold Crane, forced to confront his own role in nearly sending an innocent woman to prison for life, underwent his own painful transformation. In a statement to the legal press that shocked his colleagues, he acknowledged that professional arrogance and institutional blindness had prevented me from recognizing legal brilliance simply because it came from someone whose job title didn't match my expectations. More significantly, Harold reached out to Daniel directly, their conversation taking place not in his prestigious corner office, but in the same courthouse cafeteria where ordinary people struggled with legal problems every day. "Mr. Davis," Harold said, his usual commanding presence replaced by something approaching humility, "I owe you more than an apology. I owe you recognition that you were right about everything. About the constitutional violation, about Victoria's innocence, and about my own prejudices blinding me to the truth." Daniel studied the man who had dismissed him so contemptuously just a week earlier. "Mr. Crane, what matters is that Victoria is free, and the real issues in our criminal justice system are finally being addressed." Harold nodded slowly. "I want to make you an offer. Senior associate position at Whitmore Associates, starting immediately. Full partner track with compensation that reflects your demonstrated expertise. We need minds like yours, and frankly, we need the humility that comes from understanding that brilliance doesn't always come with the credentials we expect." Daniel was quiet for a long moment, considering an offer that would have seemed impossible just days earlier. "Mr. Crane, I appreciate the recognition, but I think my path lies elsewhere. Professor Kane has offered me the chance to complete my legal education at Harvard, and I believe that's where I can make the most difference, not just as a practicing attorney, but as someone who can help change how the legal profession identifies and nurtures talent." As Harold walked away from that conversation, he carried with him a lesson that would reshape not just his own practice, but his understanding of what expertise really meant. The janitor who had humbled him had also taught him that true legal brilliance wasn't about where you went to school or what title you held. It was about understanding justice deeply enough to fight for it, regardless of the personal cost. The transformation of Daniel Davis from invisible custodian to legal reformer was complete, but the broader change he had catalyzed was just beginning. Across the country, other hidden legal minds were beginning to emerge from the shadows, emboldened by the knowledge that their insights mattered and that the profession was finally ready to listen. 2 years later, Professor Daniel Davis stood at the podium in Harvard Law School's most prestigious lecture hall, looking out at 150 eager first-year students who hung on his every word during his constitutional criminal procedure course. The same classroom where he had once sat as a struggling student 15 years earlier now served as his platform for revolutionizing how future attorneys understood both legal principles and the humility required to serve justice effectively. "Today, we're going to discuss the Hartwell case," Daniel announced, and the students immediately perked up. They all knew the story. It had become required reading in criminal law courses across the country, a case study in how institutional blindness could nearly destroy an innocent life. "Can anyone tell me the most important lesson from this landmark decision?" A confident second-year student raised her hand. "That even experienced attorneys can miss obvious constitutional violations if they're not careful in their document review." Daniel shook his head gently. "That's one lesson, but not the most important one. Anyone else?" A quieter student in the back row tentatively raised his hand. "That legal expertise can exist outside traditional institutions, and that we should be open to insights from unexpected sources." "Closer," Daniel nodded encouragingly, "but still not the core principle I want you to understand." He walked to the whiteboard and wrote a single sentence. Justice requires the courage to question our own assumptions about who deserves to be heard.
The Hartwell case wasn't ultimately about one janitor's legal knowledge or one attorney's professional pride, Daniel continued. It was about a legal system that had become so focused on credentials and hierarchy that it nearly sent an innocent woman to prison for life rather than examine evidence that challenged those hierarchies. From the back of the lecture hall, a familiar figure slipped quietly through the doors. Emma Davis, now 14 and one of the top students in her high school's advanced placement program, often attended her stepfather's lectures when her own classes ended early. She had become something of a celebrity at her school since Mrs. Henderson's constitutional knowledge incident had been featured in a national documentary about educational bias and hidden student potential. Professor Davis, another student asked, how do we ensure that we don't fall into the same trap of institutional blindness when we become practicing attorneys? Daniel smiled, remembering asking Professor Kane a similar question 15 years earlier. By remembering that every person you encounter, whether they're wearing a custodial uniform, serving your coffee, or sitting across from you in a client interview, possesses knowledge and perspectives that could be crucial to achieving justice. The moment you assume someone has nothing valuable to contribute based on their appearance or job title is the moment you stop being an effective advocate for your clients. As the lecture concluded and students filed out discussing the implications of Daniel's teachings, Emma approached the podium with the kind of proud smile that only family members could wear. "Great lecture, Dad," she said, using the title that still made Daniel's heart warm every time he heard it. "I especially like the part about institutional blindness. It reminds me of something that happened at school yesterday." Daniel raised an eyebrow. "Oh?" "We have a new custodian, Mr. Reginald Washington. He's been listening to my AP Physics discussions with friends during lunch, and yesterday he quietly mentioned that our teacher's explanation of quantum mechanics was missing a crucial component. Turns out Mr. Washington has a PhD in theoretical physics from MIT, but couldn't find work in his field after being incarcerated for a nonviolent drug offense 15 years ago." Daniel felt a familiar stirring of recognition and purpose. "What did you do?" "I talked to Miss Garcia, my physics teacher. She's agreed to let Mr. Washington guest lecture next week about his specialty area. And I'm working with the principal to create a program where staff members with expertise can contribute to classroom discussions regardless of their official job descriptions." As they walked together across Harvard's campus toward the law school student parking area, Daniel marveled at how his daughter had internalized the lessons from his own journey and was already applying them to create change in her own environment. Their conversation was interrupted by Daniel's phone buzzing with a call from Jennifer Walsh, who had left Whitmore Associates 6 months after the Hartwell case to become a public defender dedicated to representing clients whose cases traditional firms wouldn't take seriously. "Daniel," Jennifer's voice carried excitement through the speaker, "I have another case where constitutional violations are hiding in plain sight, but this time the defendant can't afford private counsel, and the overworked public defender's office is missing the issues. Could you review the file? It involves a search and seizure case that seems eerily similar to what happened with Victoria." Daniel glanced at Emma, who was listening with the kind of intense attention she gave to problems that mattered. "Dad, do you ever regret the path that led you here? The years of working as a janitor, the financial struggles, missing out on the traditional legal career you originally planned?" Daniel considered the question carefully as they reached his modest hybrid vehicle, a far cry from the luxury cars driven by his law school classmates, but perfectly suited to a professor who valued substance over symbols. "Emma, 15 years ago, I thought my life was derailed when I had to leave law school to care for your Aunt Rebecca. I believed that financial necessity had stolen my dreams and condemned me to invisible work that would never matter. But now I understand that those 15 years of watching the legal system from the outside, of experiencing economic struggle firsthand, of raising you and learning from your mother and staying connected to real people facing real problems, all of that made me a better legal mind than I ever could have been if I'd followed the traditional path."
They drove through Cambridge in comfortable silence until Emma asked one final question. What do you want people to remember about your story? Daniel thought about Victoria Hartwell, who now ran a nonprofit organization providing legal literacy education to low-income communities. He thought about Harold Crane, who had transformed his practice to focus on training young attorneys about unconscious bias and institutional blindness. He thought about the dozens of law firms that had created partnerships with community colleges and workforce development programs to identify hidden legal talent among non-traditional candidates. I want people to remember that brilliance exists everywhere, Daniel said finally. In the person who cleans your office late at night, in the server who brings your coffee, in the maintenance worker who fixes your computers, in the student who asks uncomfortable questions that challenge your assumptions. I want them to understand that our society wastes incredible amounts of human potential simply because we've convinced ourselves that intelligence and insight only count when they come with the right credentials or the right background.
As they pulled into their driveway, Daniel noticed Sarah grading papers at the kitchen table through the window, her commitment to nurturing every student's potential unchanged after all these years. Rebecca's car was in the driveway too. She often joined them for dinner now, her own career as a medical technician flourishing as she helped train other healthcare workers who brought non-traditional backgrounds to medical settings. But most importantly, Daniel continued, I want people to understand that fighting for justice isn't about having permission from institutions or approval from people in power. It's about having the courage to speak truth when truth needs to be spoken, regardless of whether anyone wants to listen. Victoria Hartwell's freedom didn't depend on my having the right diploma on my wall. It depended on my willingness to step forward when I saw injustice and had the knowledge to address it. Emma nodded thoughtfully as they gathered their belongings from the car. Dad, I think Mr. Washington at my school might need someone to believe in him the way you believed in yourself when you discovered that constitutional violation. Would you be willing to meet with him? Daniel smiled, recognizing in his daughter's question the same commitment to justice that had driven him to approach Harold Crane that midnight 2 years ago. Of course. And Emma, I'm proud of you for seeing potential where others might only see a job title. As the Davis family gathered around their dinner table that evening, Daniel, Sarah, Emma, Rebecca, and now Mr. Washington, who had joined them for a conversation about physics, law, and the hidden expertise that surrounded them all, they embodied the transformation that one man's courage had catalyzed. Justice, they had learned, wasn't dispensed by institutions or guaranteed by credentials. Justice emerged when ordinary people with extraordinary knowledge chose to fight for what was right, regardless of whether the system was ready to recognize their authority to do so. The story of Daniel Davis had become more than just one man's vindication. It had become a reminder that in a world full of hidden potential and overlooked brilliance, the most profound changes often came from those humble enough to clean floors and bold enough to challenge the assumptions of those who walked on them. And somewhere in New York, Victoria Hartwell was tucking her son Marcus into bed, telling him once again about the man who saw her innocence when everyone else saw only her guilt, who understood the Constitution when everyone else saw only complicated legal theory, and who proved that sometimes the most important truths are discovered not by those with the most impressive titles, but by those with the courage to look closely at what everyone else had stopped seeing. Up next, you've got 2 more standout stories right on your screen. If this one hits the mark, you won't want to pass these up. Just click and check them out. And don't forget to like, subscribe, and turn on the notification bell so you don't miss any upload from us.